Okay, so I think we can begin. Welcome everyone to this presentation, which is titled Who Owns What, Where and How, Beneficial Ownership Transparency in Africa and in Latin America. Before we start, I just want to highlight that we're going to have panelists in Spanish and in English, so please do turn on the interpretation. You can do so by clicking in the button at the bottom of your screen that shows the language that you prefer to follow the event in. We have interpretation in English, Spanish, and French. And also the second point that I wanted to make is, do please, if you have any questions, do please use the question and answer button at the bottom of your screen. We will come back to those questions after the main panel, but please use that feature of Zoom to center your questions. Okay, so just to introduce, my name is Florencia. I'm a senior researcher in the Tax Justice Network. And today this event is, it marks the launch of two reports which display the current state of play of beneficial ownership registration and transparency, both in Latin America and in Africa. We consider that this publication is very relevant to the current context, especially because as I hope we'll discuss later today, the environment of beneficial ownership transparency is one which is always moving very quickly, with new standards being implemented, new rules implemented in different countries, and sometimes even overruled with time. So keeping up with these developments is very important to anyone which is interested, and it's often quite hard, especially because they are always changing. And also we are moving towards a moment that beneficial ownership registration and transparency was a standard and advocacy ask, to a moment where most countries, as you will see, are implementing some sort of beneficial ownership registration rule. So this event will also allow us to discuss a bit how this implementation is taking place, look at good examples, issues that need to be overcome. And we are going to do this by going through 4 rounds of questions in which we will ask our panelists to give us their opinions. Just to give a brief introduction, we'll be joined by 4 panelists today, which are Francis Cairo, who is a policy officer at the Tax Justice Network Africa, where he works with topics of tax and international financial architecture. Maria Eugenia Marano, who is a lawyer, specialist in economic crime and a consultant for Fundación. My colleague at the Tax Justice Network, Rachel Ether-Foya, and who is a senior researcher at the Tax Justice Network, and Andres Noble, who is a lead researcher on beneficial ownership in the Tax Justice Network as well. Before we go into the questions, I'm just going to give a very brief overview to the reports, and then we'll continue with our panelists. So these are, both reports look at data from the Financial Secrecy Index, but also research in collaboration with our partners to analyze the frameworks of beneficial ownership registration in the region. And here, these both maps, which are better described in our reports that we'll share in the channel, in the chat below, represent an overview of the current state of play in each of the regions. So in Latin America, out of the 16 jurisdictions we analyzed, 10 of those already have already are requiring beneficial ownership information to be registered with a governmental authority. And in Africa, out of the 54 jurisdictions that we look, 23 now have laws that require beneficial owners of companies to be declared or registered with the governmental authority. This map from Africa also show that even those countries that don't have like overall registration systems have implemented some commitments, at least in some sectors, such as the extractive sector or the disclosures within the COVID recipients funds. So both reports shows a consistent tendency towards implementation of beneficial ownership registration frameworks, and they also show that this issue has become very relevant for an increased number of actors which are involved in these policy networks, of course, with regional and domestic particularities, right? Which we'll discuss further on. The reports also shows how some countries have become leaders in some areas, adopting low thresholds, comprehensive scopes of registration and triggers of registrations. And they also point to some incipient moves towards beneficial ownership transparency, that is information of beneficial ownership information being available to the general public. But they also show that there is still a lot that needs to be improved. The loopholes need to be closed. We need to effectively regulate bearer shares, and we need to move towards more transparency of ownership of legal vehicles. The reports include case studies, which in the case of the report on beneficial ownership transparency in Africa, look at the misuse of legal vehicles to channel illicit financial flows. And in the case of the Latin American report, we look at the actual implementation of some frameworks, how they took place, and some of the issues that happened during this implementation process. I'm going to stop here. I'll share the reports in the chat. But now I want to continue with our panelists and move to our questions to hear their views on some specific points. And the first question that I wanted to ask, and here I'm going to ask to Maria Eugenia Marano, is in which context is beneficial transparency vital? So I want to hear from all of our panelists. I'll begin with Maria Eugenia, and then we'll go through the other ones. So please, welcome, María.
Bueno, muy buenos días a todos y todas. En principio, gracias por la invitación a participar de este panel y de la elaboración de uno de los documentos. Fundamentalmente yo creo que es clave la transparencia de los beneficiarios finales en todo lo que tiene que ver con el tráfico de los flujos financieros, ya sea ilícitos, que es mucho lo que a nosotros nos interesa, lo que tiene que ver con delitos de lavado de activos, sus delitos precedentes, como sí también lo que tiene que ver con los flujos financieros lícitos, también como para dar marcos de transparencia a todo lo que es el tráfico mercantil, la relación entre los privados, el conocimiento efectivo de con quién estamos contratando, o bien en términos de relaciones de familia también, muchas veces se busca dar opacidad a los verdaderos dueños con fines de ocultamiento de bienes, con lo cual es amplio el universo de motivaciones que nos obligan a tener que dar transparencia a los beneficiarios finales, a quienes resultan ser los verdaderos dueños detrás de las personas y estructuras jurídicas.
Muchas gracias, Maru. I'm going to please ask you, Kairi, to also give us your view on this topic, and why do you consider in which context do you consider beneficial ownership transparency to be vital?
Yeah, thank you, and welcome to everyone. Happy to participate on this panel. And we also invite you to look for more details in the reports. I think they are by far one of the most systematic analysis of beneficial ownership laws and legislation, across the two places. And I think it is important to point out that there is a direct correlation between fiscal transparency within a country and improvements in the fortunes of that country. And therefore, beneficial ownership comes to play this role of increasing how transparent systems are, how transparent government is, how transparent the companies that are doing business in a country, either with individuals or with government are. And I think in terms of even pushing for, the better context, I think it is important to realize that it is at the point where most developing countries are developing their systems that it is crucial to push for transparency. And therefore, beneficial ownership in the context of developing countries is a key consideration, because when the government is setting up their systems, when the government is thinking about how it is going to engage with big business, when the government is thinking about how it's going to improve dwindling fiscal reserves, then one of the ways is ensuring that the beneficial owners of companies are known. Within that context of a developing country, we will not be able to achieve any meaningful transparency without beneficial ownership transparency.
Thank you so much, Edu, for this. Rachel, so Manu has pointed issues around the different elements of illicit financial flows, and then Cairo has highlighted the specific context of developing countries for this. And I would also like to hear your view, Rachel, on what specific context this would be relevant for.
Thanks, Florencia, and welcome everyone. Good afternoon from Lilongwe, Malawi. So I wanted to start off by telling a story that we included in the report. In Cameroon, in response to the coronavirus pandemic, like many governments, they set up a special fund, and they set up a working group within the Ministry of Health to administrate this fund, to get in more test kits to support the healthcare workers, to improve infrastructure needed to respond to the pandemic. But quickly on social media, on WhatsApp, there were lots and lots of messages about fraud and embezzlement. The mainstream media picked this up, and even President Paul Biya called for an investigation. And so in an audit by the audit bench of the Supreme Court, they pointed out lots and lots of different reasons why drugs weren't being supplied, why test kits were overpriced, and all sorts of other materials just were much more expensive than they should have been. And the audit uncovered that there was a contract amounting to over $5 million to companies that were owned by the president of the working group set up by the Ministry of Health and his younger brother. And it seems that also his older brother benefited with 6 contracts awarded to 3 companies that he was managing. So I share this just to illustrate the point that beneficial ownership transparency has to be in place if we want to see good value for the money being spent by government on public services. And that's one of the sectors that's really important across the world.
Thank you so much for bringing this example, because I think it helps to give a bit of flesh and bone to the topic that sometimes can be a bit abstract. Andres, I would be keen to hearing what is your opinion on the topic as well, if you have some specific context that you think we should be looking at when we talk about the
Thanks for the question. Actually, this is one of the topics that we have been, I've been trying to work on a paper for this for a long time, this holistic approach. Why is BO? There are many sectors where it's vital, but it's really one thing that can really change all of the country. And now, after the EU Court of Justice ruling, that we are being forced to now think of and justify other uses beyond anti-money laundering and tax, which are the most common ones. So actually, I'm working now on a paper, and I've been identifying between 20 and 30 other specific topics. So we have, of course, anti-money laundering and corruption, and this can include conflict of interest, suppliers, unjustified or illegal enrichments, payment of bribes, but then also the evasion of sanctions, very relevant now when we think of the Russian invasion of Ukraine, as well as any other means to undermine democracy, as we have fake news and fake ads and trying to determine who is behind all of those fake identities. As the Tax Justice Network, we of course care a lot about tax abuse, and BO transparency, beneficial ownership is so relevant for personal income tax evasion, corporate income tax fraud, capital gains tax abuse, wealth tax abuse, inheritance tax abuse, dividend tax abuse. There's so many different taxes that can be tackled, the abuse of these taxes. We can think of fraud and administrative violations from bid rigging and market concentration, but then it's also relevant beyond authorities and even just for regular citizens and business people and firms. So there's a lot about fair market conditions, from doing a due diligence to know who you're doing businesses with, as well as to determine insider trading, or even finding some cases, some from Argentina or from Canada, about reorganization of planned fraud. So basically where a company is about to go bankrupt, and sometimes the beneficial owner is creating a fraud scheme so as to defraud creditors, as well as when a company is trying to even bankrupt themselves, as a case from Canada. And of course, also to help measure how we're doing as a fair society. from gender inequality and determining how many beneficial owners are women and how many are men, estimating inequality in general, and protection of women in divorce proceedings. And that's where we see, for instance, the role of trust as a legal vehicle that can be especially used to defraud women. So these are some of the ideas that we're working on to show how BO is so much relevant beyond anti-money laundering.
So much for that. So I think we now have reached to a point that we have like so many issues that point to the relevance of the topic and so many areas in which is vital. And now when we can discuss about how to deal with this, we start looking at inspiration, right? Which countries are doing a good job and which that may lead the way or help other countries which are in the process of trying to implement a BO framework. So Rachel, I wanted to begin with you, asking you where should we be looking for inspiration of beneficial ownership transparency, if you have some thoughts on that?
Thanks, Flor. So in Africa, we should be looking at Botswana for sure. So one of the most important things for countries to get right to begin with is having a really clear definition of who a beneficial owner is. And without it, there's just going to be too many loopholes. So beneficial ownership definitions typically use thresholds to like narrow the scope of who should be identified as an owner. But the problem with having a threshold is no matter how small it or low it may be, it just kind of creates room for people to be able to maneuver around the rules. So for example, if your definition includes a threshold of say 10%, then by simply setting up a company with 11 owners with equal shares, a company could avoid registering any beneficial owner because each of them would fall under 10%. And that's where Botswana comes in. So in Botswana, there is no threshold for the requirements for owners to register with the companies and intellectual property authority. So basically means in Botswana, every individual who owns a share, at least directly or indirectly, has to register with the companies and intellectual property authority, which is a really fundamental step. And I think that's a thing that we can take inspiration from across the world.
Thank you so much. Maria Eugenia, if you want to give us your views, especially in the region of Latin America, if you have a country that you think we should be looking at specifically.
Y se me vienen muchas ideas. La verdad que América Latina ha venido creciendo mucho en estos últimos años. Yo creo que un caso de inspiración ha sido el de Ecuador, con el desarrollo tecnológico que tiene, si bien todavía existen algunas lagunas que resolver como para armonizar toda la normativa que tienen, creo que ya tienen desarrollados un importante sistema, un importante portal de información que es pública, que con un pequeño ajuste estarían cumpliendo perfectamente con el estándar, y bueno, definir el tema de quién es la autoridad que finalmente va a llevar en cabeza este registro, y unificar algunas definiciones. Yo creo que dentro de lo que es la región de Latinoamérica, es el mejor ejemplo que podemos tomar. Y Argentina, por ejemplo, viene avanzando bastante, también con un diseño importante en lo que tiene que ver en cabeza de la Administración Federal de Ingresos Públicos, pero con un registro que todavía no termina de ser público de momento. Pero creo que también avanzando en esta línea y con un mejor desarrollo y este impulso que también se está dando desde la sociedad civil, podemos con otras aristas lograr llegar a este registro.
Gracias. I would also like to hear your views on this. And here I am thinking about inspiration both on transparency, but also on the other dimensions of the framework, because I would want to hear what do you consider is a case that we should be paying attention to. For me.
Botswana, because it is one of the countries that provides open or rather access to legal owners. So indeed agree with Rachel. But I think several countries across Africa, countries like Kenya and Ghana, that have made very great strides in coming up with beneficial ownership laws that have some of the good parameters that we within the movements have been fighting for, things like identification and things like a central register for beneficial owners. So I think there's great inspiration for that. Nigeria, I think for a while has also been showing good, good progress by, for example, providing access to beneficial owners, at least within the extractive industry. So I think generally there's good traction, but I also wanted to bring it bigger and say that if you look at Africa in general, when it comes to pushing for good standards in reforms of the international financial architecture, I think Africa has been leading the pack. And I think building onto that momentum and ensuring that the ball is not dropped, and ensuring that at least our governments, because they have spoken in one voice, for example, at the UN on an issue regarding the UN Tax Convention, I think we need to see more of that. We need to see more of governments coming together to push for common positions, like opening up registers and for example, saying that pushing for privacy laws that come to restrict certain things is not a good thing. So I think there's a case there to look towards African leadership and building on that momentum to achieve some great goals.
Thank you, Cairo. I really like the point that you make, that we should look both at the level of the legal frameworks and how they have been implemented, but also at the political strengths of some regions and how they have managed to build that strength, which I think is a crucial point where we are talking about real change, right? Andres, I would like to push the ball for you now on where should we be looking for inspiration as well. I'm interested.
So I definitely agree with everything that has been said so far by the other colleagues. I would say two more things. On the one hand, I feel like there's usually a wrong interpretation, especially by countries and especially international standards, about the role of beneficial ownership, which is just to identify the very few that control. Whereas our perspective is that no, we will never find that out, most likely. So we just want to get as much information as possible. And then we will see how we analyze that, how we find unknown relationships. So on the one hand, what Rachel was saying about no thresholds is definitely the best approach. But then we also have another interesting case in Latin America of Colombia. Even though Colombia has a rather high threshold of 5%, which is better than others, but still a threshold in itself. But Colombia does cover three elements in the definition. So it doesn't cover only control as voting rights or only ownership, but it also covers benefits. And either of them is enough to determine a beneficial owner. Now, the other side of a good example would definitely have to be Ecuador, as Mario was saying. And because of Kairo's point, the most crucial point right now is publicity. Not only because of the court justice ruling, again in Europe, that will have global effects in a way, even though it is not binding, but of course countries are looking into that. But in a way, at the Taxes Network, what we mostly do is look at the legal frameworks. But now the only way to really know how enforcement is happening, how implementation is really going on, is to have access to information, is to know, to see really what is registered there and how good the quality is. So it was, verification became a topic only because of Global Witness's access to the UK's register. Otherwise, we wouldn't know. We were able to know how bad Australia automatic exchange of information might be because they published statistics, and we found out that banks were identifying Antarctica. So basically, if we don't know what countries are doing, we simply have to blindly trust them. So the only thing is really to start having and pushing countries to have public access. And in that case, of course, we have good cases in Europe, like the UK or Denmark or Latvia, but we have very good examples. And Ecuador in Latin America is a great example of a free online and public register for trust and for legal persons. So it really shows other Latin American countries, as well as EU countries, that it can be done.
Thank you so much. Yeah, that's all very interesting points. And I think that they also set a bit of the stage to the discussion of how the institutions responsible for setting up the global standards on beneficial ownership transparency are doing in their job. So if they're being effective or not, where can it be improved? And I would like to start now with Cairo, if you have any thoughts on that, and like on the issue of how should we be discussing the standards and where should we be following this discussion?
Yeah, thank you, Florencia. I want to start by throwing a spanner into the works. One of the big issues with the most international institutions is actually the question of legitimacy, because you will often find that most of these institutions have come about because of a need that there was a gap that needed to be filled in. And most of them do not enjoy the kind of legitimacy that we within the movement have been pushing for. You have, for example, institutions that, for example, are set up under the OECD, and you end up having, little representation from African countries, little voice, little contribution, and that actually affects the legitimacy of these institutions, to keep developing rules and implementing those rules. It becomes harder for compliance and implementation of certain rules where some countries or most countries within the developing countries were not involved in shaping the rules, in developing the rules, and it becomes therefore hard for implementation. However, you also have on the other side those that are also doing a commendable job, because I think in terms of developing key BO standards, I think there has been very good leadership. The only issue has been, how to trickle it down, how to bring it down to country level, and how to ensure that at country level, there's good compliance. And as you know, because most of these institutions do not have the big whip of, sanctioning, for example, countries or ensuring that countries can comply with some of these rules, it becomes harder. However, that can be overcome by attaining more legitimacy, ensuring there is more participation of more countries. And therefore, when these rules are developed, it becomes almost easy for countries to look inward, sharpen their laws and ensure that their laws are cognizant and responding to certain good and international international best standards on BO.
Thank you, Cairo. Maru, I would like to hear your opinion on this as well. What do you think about this discussion on how institutions? Yes, sorry, please go ahead.
Ok. Sí, comparto, justamente venía pensando algo similar en esta sintonía de que los estándares son reglas generales y después somos los países los que debemos bajarlo y trasladarlo a nuestras normas y a nuestros sistemas, con lo cual es necesario hacer un análisis integral, fundamentalmente que todos los países, la mayor cantidad posible, tengan este acceso a participar de estas recomendaciones, pero que después en el trabajo interno o en el acompañamiento se pueda comprender los sistemas jurídicos de cada uno de los países, las limitaciones, las posibilidades de transformar esas limitaciones también, pero tiene que ser un análisis armónico de los sistemas, porque muchas veces en este afán de los países de cumplir con el estándar a rajatabla, perdemos de vista la posibilidad de que este sistema sea efectivo, porque tal como está no puede ser efectivo en el país que lo recepta a este estándar. Yo creo que es clave este trabajo conjunto, esta participación global, para que efectivamente todos los países puedan cumplir, puedan llegar a tener sus sistemas y registros efectivos, porque tampoco tenemos que perder de vista cuando hablamos de los delitos involucrados, lo transnacional y la necesidad de tener esta información de manera rápida y efectiva desde cualquier lugar del mundo, con lo cual estos sistemas deben estar también armonizados y tienen que tener esta posibilidad de ser eficientes y efectivos.
Muchas gracias, Maru. Sorry, Rachel, I would like to hear your views on this topic as well, if you have any points.
Thanks so much, Florencia. Yeah, so I really echo what Maria and Cairo have said around the Legitimacy Forum, and that really important part of translating these global standards at the national level. And this looks really different contexts, depending on also even the extent to which government institutions are digitized or not. So I wanted to take a look at a particular sector, because in the report we looked at commitments made in the extractive industries in Africa, because it's such an important sector for so many countries in the region. So in Africa, 28 out of the 54 countries are part of this global standard for the Extractive Industries Transparency Initiative, and disclosing to the public the beneficial owners of mining, oil and gas companies, and in some cases forestry companies, is part of this process. And even though it's a voluntary standard, in many ways the EITI has been a front runner, spurred on by the efforts of many civil society and activist groups around the world, and also supporting companies. And then we've also seen that it's started the conversation in one sector in the country, but sort of overflowed into other sectors. So it's really important. And this year, there's an opportunity to influence the standard to go further on beneficial ownership transparency and anti-corruption measures, because the standard will be revised. And at present, how a beneficial owner is defined and how beneficial ownership disclosure occurs is very loosely defined in the standard. And I think there's an opportunity, because of the importance of the standard in many ways in many African countries, to set threshold requirements and to reward countries that have no thresholds. And it also could require in the new standard that not just a beneficial owner needs to be disclosed, but the entire complex control chain of the company structure, because this would illustrate how each beneficial owner maybe benefits or controls other legal vehicles, which is really important in the extractive industries where there's such a large number of subsidiaries, which has huge implications for tax and ability of tax authorities to make sure that taxes are being paid where they should be.
Thank you so much, Rachel. Andres, I would like to hear your views on this as well.
Yeah, here I might have a bit of a different perspective of some of the other speakers, in the sense that I really believe in beneficial ownership transparency. And of course, it would be amazing, really great if every country and every stakeholder in a country took ownership of beneficial ownership transparency. They saw the interest, they saw the value in it, and really pushed it. Unfortunately, that is many times not the case. And what we see to be the case is that countries start implementing changes, not because they believe in them, because they want to, but just because it comes imposed from abroad, from international standard. I mean, if we think even of automatic exchange of information, which is one of the policies that the Tax Justice Network has been asking for a long time, it was not that banks wanted to do it. I mean, they were complaining. It was not that countries wanted to do it. They were also complaining. It was just that they were forced to do it. From FATCA to the CRS, I mean, there were different reasons, different standards that happened that forced countries. And thanks to that, we now have this automatic exchange system, which is not perfect, but it exists. With beneficial ownership transparency, even though, again, I just listed earlier, all these reasons why it's so relevant for the whole country, the whole economy, still many do not believe in them or do not see there's a huge value in them, or they don't find it as a priority. So in that sense, I think international standards done by international organizations have a crucial role in improving the standards and making sure that they will be applied. Of course, they need to start putting way more pressure on the major financial centers and not just on the smaller countries. I mean, of course, we have countries like Switzerland that still don't even have a BO register, or we have cases like the US that has a new recent law, which is still not enforced and still has many loopholes. So, of course, these are the countries that should be changing things the earliest and the fastest. But at the same time, we do expect standards to be better. I mean, they don't even yet call for public access, even though they consider that. They don't even require for a register in all cases. They still allow for alternative mechanisms or not even require that at all. So there's still much more that the standards should be doing to really make the world more transparent, because at the end of the day, it will be up to them. Of course, there should be a lot of work, and many civil society organizations are doing exactly what Mari was saying, trying to have the discussions, trying to have countries and stakeholders take ownership. But until that happens, that can definitely be helped by more push by international standards to have better standards instead of these loose ones that allow you to choose a 25% threshold.
Thank you, Andres, on making those points. Then we'll head to like the last question that we will discuss in the panel, and we'll go into the question and answer. I do want to invite the panelists to, if you think you can answer some of the questions, please feel free to do that by written, but we'll come back to those. And then the last question is looking a bit to the future, to think a bit about what does the future of beneficial ownership transparency should look like? What does this future holds? Maybe I can go back to you, Andres, on this one, and start by you, but to change a bit the order, because I know that you always had like so many ideas on the topic. So
I guess too many ideas, but maybe to start off, I would say two main things. The first one is that we're not covering the right legal vehicles, and there's also a question that otherwise I can respond later. So many times when we think about beneficial ownership, and again, even we think for a small company that it's very easy to have like 4 shareholders and then they don't pass the 35% threshold. But sometimes the biggest macro critical companies in the country can be investment funds or companies owned by an investment fund or by listed companies. And many times they are excluded. Either they are automatically excluded just because they're listed, or the thresholds that apply clearly are irrelevant for them because it's very unlikely to have a person or individual owning more than 25% of an investment fund or a listed company, even though these can be worth billions or trillions and have a lot of interest in a country. So on the one hand, the future has to start covering, appropriately covering these two types of legal vehicles. And then the other one has to do with, again, biotransparency is relevant, but it doesn't even end there. It's still a tool, and the main tool is to link that to asset ownership. And that is why, at the end of the day, beneficial ownership transparency, when we think of who the owners and controllers of a trust or a company are, that is especially relevant to know who owns and controls all of the assets, from real estate, a yacht, private jets, and all the things that are happening in the economy, how they got them, measuring inequality. So at the end of the day, the future should be linking this to asset ownership.
Thank you so much. Cairo, I would also like to hear your view on what does the future holds for Bio.
I could keep going on and on and on. It's such an interesting question. But from my own assessment, number one, I think from what we saw with the EU Court of Justice, where there's sudden, a sudden big pushback, and suddenly you have people who are saying privacy now over some of the things that we have been talking about. So I think we expect more pushback against greater transparency, especially now that we know that the stakes continue getting higher as companies become more wealthier, as they do more business in more countries, and ensuring that, for example, our politics will be good, I think is a key consideration to ensure that pushback does not continue. Additionally, I think we ought to move from commitment to action. If you look at our report, we have itemized a number of countries that have made commitments toward biotransparency, but action needs to come. We cannot stay longer in commitment. So we need to see more, and we need for bigger pushes from civil society. We need government recognition of the need to move from commitments to action. And I think there's also the next step. I think, as Andres has mentioned, that it is just a tool, and as a tool, how it functions is also very key. So countries also need to move from just having the law to proper implementation. We need, for example, to see countries doing better on bio standards, things like proper identification of declared beneficial owners, things like proper verification of those that have been declared as beneficial owners. We need to see more compliance. A country like Kenya recently reported that they have about 40% compliance with the beneficial ownership requirements. So we need to see governments enforcing in a way, or enticing or incentivizing compliance with bio laws. So having the law is just one step of the way. But moving forward to ensuring that there is compliance with the law, and ensuring that the law is being implemented, I think is very key. I could keep going on and on and on, but let me stop myself here.
Thank you. Yeah, this is a topic that we all have so many opinions, so it's easy to get, continue for a long time. Maru, I would like to hear your views on this topic, on what is the future for biotransparency.
Sí, efectivamente me pasa lo mismo, porque los iba escuchando e iba anotando, y me terminó como una lista enorme que no llevaría. Pero yo creo que es clave esto, como mencionaba Andrés, realmente internalizar la importancia que significa contar con la información de los beneficiarios finales. Poder entender que hoy el mundo necesita salir de las crisis por las que está atravesando, y contar con esta información también es muy beneficioso para poder emprender un camino de ascenso y de crecimiento en todo sentido. Es clave trabajar en conjunto entre todos los registros, justamente los registros de bienes, los registros de empresas, con lo cual es un tema que debe ser de agenda, que por suerte va ocupando de a poquito mayores lugares, va tomando visibilidad. Yo siempre digo, es un tema bastante joven dentro de lo que es el término jurídico, por un lado, y ni hablar en términos de idiosincrasia y de creencias sociales, empresarias y de prácticas empresarias que lo primero que ponen es una resistencia a brindar esta información. Con lo cual hay que seguir trabajando muchísimo en capacitación, en estos debates, en estos intercambios de ideas y en poder visibilizar esta importancia que conlleva tener registros centralizados, públicos, transparentes de información de quiénes son los verdaderos dueños, de qué, porque no debemos olvidar que cuando hablamos de estos temas también, de fondo tenemos la importancia de los sistemas económicos financieros de los países que tienen que sostener a la sociedad. Con lo cual, si esto se quiebra, si los países dejan de recaudar impuestos, si los países permiten que se fuguen las divisas, si los países no tienen sentencias firmes, efectivas, en razón del lavado de dinero, la lista es enorme de los beneficios que nos traería en términos de plazos también, ¿no? Porque se acortaría mucho las investigaciones si pudiéramos saber a ciencia cierta o al menos acercarnos, ¿no? Acercarnos a quién es este verdadero dueño. Con lo cual nos queda un largo camino. Yo creo que vamos andando mucho, nos falta, pero bueno, también estas actividades de la sociedad civil son claves para seguir poniendo el tema en agenda, como vienen ya trabajando desde Tax Justice hace tantos años, desde Fundación CES hace tantos años, en encuentros, y las convocatorias son cada vez mayores y las inquietudes también, y eso creo que es muy positivo, así que hay que seguir avanzando, fortaleciendo y trabajando en conjunto con los estados para ver de qué manera podemos llegar a toda la comunidad y a que todos comprendan los beneficios de contar con esta información.
Gracias, Maru. Rachel, I would like to hear your thoughts on this. And then we can go to
Great. So yeah, I mean, I could also bring out my laundry list of many aspirations for beneficial ownership transparency. I think what we were really excited to see when we were developing the report is that, I mean, as of January this year, 23 of 54 African nations now have a law requiring the owners of companies to register with the government authority. This is brilliant. But as all my fellow panelists has said, like having the standard and even having the data is not enough to stop corruption or corrupt practice. It's not enough to level the playing field, because it actually needs to be used to start off with by government authorities, but also the stakes are often high in situations where government is negotiating a mining agreement or is entering large procurement contracts. And because the stakes are so high and because there's a lot of money involved, there's also huge and high opportunities for political interference. And that for me is one of the fundamental reasons we need public access to beneficial ownership registries, because the public can often play a role in supporting those civil servants who are trying to do their jobs right when this information is in the public domain. Because I've heard quite often stories of procurement committees where everyone actually knows who the beneficial owners of the companies are involved, even when there's no transparency rules, because there's been pressure to make a decision in one way or the other. But having a registry that is public, when we put this in the public domain, and those officials that aren't succumbing to pressure and who are really heroes in our public systems can have the support of the public and citizens and journalists in their efforts to make sure that beneficial ownership, transparency, information and data is used for the purposes that it can serve in our societies. And so I'm really hopeful about that when we see a push towards more public disclosure. And obviously, as we saw, as Kara was mentioning, with the recent EU Court of Justice decision that invalidates public access to beneficial ownership registries in Europe, is a step in the wrong direction. But I'm hopeful, as Kara was saying earlier, Africa and other regions are showing leadership on this. We had a brilliant example from Ecuador earlier as well. So we just need to keep going in the right direction and encouraging our governments. And yeah, because it's a public good and it's not just about responding to international standards.
Thank you so much, everyone. I'll try to pick some questions from the question and answer, but we have so many of those. So some of those topics we do encourage you to look into our reports, because some of the topics that are being asked, we are present there. But I wanted to focus on some of the points that appear more repeatedly first, and then if we want to address another of those we can, if we have time, we can look into them. But one of the questions which seems the most consistent one from looking at different people that have asked is about, which I think it's a topic that gain a lot of relevance now within the context of the ruling of the European Court of Justice, which is how do the issue of confidentiality and how do we balance the need and the for public access with some concerns which are quite common in developing. It's a very strong argument in developing countries for not disclosing beneficial ownership information. And I would like to hear your views on this, Andres, because I think it's a topic that you have been thinking a lot about.
Yeah, I think I'm too passionate and maybe a bit too stubborn on this, but it's really hard for me to understand those points. I mean, and for many reasons. I would say that again, secrecy was never even meant to be the reason or even like the purpose or even like a goal of creating legal vehicles like a company. Even, and we had like a recent privacy webinar where even the lawyer who was behind the lawsuit that invalidated public access in the EU was there. And he was giving the example of, well, the Société Anonyme or Sociedad Anónima in Spanish, as we like, well, it was meant to be anonymous. That's why it's called like that. And that was not even the purpose of that. The purpose had to do about liability and insolvency because it was compared to a partnership, different to a company with liability where you don't even care who the shareholder is just because they will only be liable up to their investment, which is wrong in itself. And we should even be rethinking about that as we have been publishing. But so in many cases, legal owners, so the shareholders, are already publicly available. And we know that in most countries, companies choose very simple structures. So for most companies, the beneficial owner is the same one as the legal owner. And that information has been public for a very long time. And it was never meant to be secret. Now, anyone who is concerned about violence and kidnappings, which are very relevant and true concerns, and actually in many countries, including Latin America and Argentina, violence and crime is a serious issue. Now, the point is that crime does not really depend on beneficial ownership transparency. At least we haven't seen any evidence of that. Crime will most likely depend more on the wealth of a person. That means where they live, which car they drive, where they send their kids to school. All of that information can actually be publicly just by looking at who lives where and who drives which car or who puts on different clothes. None of that depends on beneficial ownership transparency. I mean, even if you own 100 companies, they could all be worth nothing. They could all be shell companies with no assets. So the idea that I think was even wrong in the court ruling, suggesting that biotransparency says anything about your wealth, that is wrong. A lot of wealth information is already publicly available. Just go out to the street, see who drives those cars. So the idea that we need this doesn't make sense. And the last point is that, again, even if there was some risk, which there might end up being some, there's still a trade-off. A lot of investigations, corruption, money laundering, tax abuses were discovered because of biotransparency or because of the Panama Papers or the Pandora Papers, which in a sense give the same information that a good public register would give. So all of that information is clearly relevant. And there's been no evidence, I mean, in countries like Ecuador or even in the UK, that even this lawyer was saying how it's been open since 2015. They have like more than 7 years and they still haven't come up with any good evidence, any good case of someone being affected because of the public's access. So all these arguments might sound emotional, might make sense, but when you look at the facts, they are really irrelevant and it's not really the point. So that's what we're trying to show. And that's why Ecuador is such a good case, because it is possible. It's been going on for years. And it's not like the country has gone on fire just because of that.
Thank you so much. I'm not sure if anyone wants to weigh in on that point. Maybe Maru or Rachel or Kaido, or we can go to some other questions if not.
I can maybe just to add something on creating level playing field around public procurement, because as just to emphasize what Andra said around many times companies, especially domestic companies, are set up in very simple form. It's just one company, the people that are registered, also the owners. So that information is already in the public domain. It's very easy for when those companies are competing for public procurement contracts, that information is already there. But it's an unlevel playing field when countries don't require the same level of transparency for companies that are more complex, where the legal and the beneficial owners aren't the same. And I think it's really important when we're thinking about domestic priorities and and the best use of our public resources as governments.
Thank you so much, Rachel. So there are like a lot of questions. So I really appreciate yes, Maru, please.
No, esto que comentaban antes, que es clave, con el ejemplo que traía Andrés sobre las sociedades anónimas, que en realidad ya no son anónimas, pero cómo esto tiene que atravesar los gobiernos para que sea una política de Estado, porque corremos riesgos que de acuerdo al tipo de gobierno que esté de turno, todas estas políticas también tiendan a desaparecer. En Argentina, por ejemplo, se está poniendo en juego el tema de las sociedades por acciones simplificadas, por ejemplo, donde resulta muchas veces complejo encontrar esa información y hay todo un sector que se opone a que el Estado conozca cómo funcionan estas estructuras jurídicas y celebra cuando se caen ciertos proyectos de ley y demás. Con lo cual, esto es un tema que tiene que atravesar los gobiernos y que tiene que ser una política de Estado consciente para que sea efectiva.
Gracias, Maru. I think we have time for maybe one last question, and I'm going to try to bundle some of the questions that that into one, which is like, and I think that this resonates with something that Andres was saying about, like, for instance, some countries like Switzerland not having a BO register. So as we discussed, secrecy works in a transnational dimension, and we see some countries which are historically known for creating a lot of secrecy risks, still allowing loopholes. So the question is, what countries can do, like especially developing, we are talking about 2 regions which are mostly of the developing countries. What can they do, and what incentives do they have if, like, secrecy can be exported? How can they deal with this dynamic? Not sure who wants to start with that question, if Rachel or Cairo, maybe you can begin with this one, because if you want.
Yeah.
Or...
I was busy typing answers to the questions.
Yeah. Maybe Rachel, if you, or Andres.
Rachel, do you want to go first? Sorry, I'm a bit sick. Sorry. Of course, it would help a lot if international standards were putting more pressure. That is actually one of the goals that we have, the tax justice network. The 2 indexes we produce, the financial secrecy index and the corporate tax haven index, point towards precisely that, showing that it's many times the biggest countries, the most powerful ones, like the US, like Switzerland, like the UK or Germany, the ones who share a lot of responsibility here. And it would be great for FATF, the Global Forum, and all these international standards to be pushing them way more than what they push smaller countries. Now, that doesn't mean that there's nothing a country could do, even a small country. So what we can still do, and what we encourage countries to do, is still to take unilateral measures. So as much as you can be saying, do not do business with this company or with this other country, or you cannot get a tax-free benefit, they could equally say, we will not recognize, say, a trust from a country that by law says they will not recognize our own laws or even our own judgments, and they have these provisions in their own laws. Or if it's a country that has issued bearer shares or allows countries to issue bearer shares, why would it allow us in a country for such company from such country to own a local company, to own a local asset? So there is still unilateral measures that countries could be doing. And actually Argentina and the commercial register of the city of Buenos Aires have done something similar to that. And one of the director generals said, some tax haven companies, offshore entities called IBCs, international business companies, they are not allowed to operate in the country where they were incorporated. They can only operate abroad. They are by definition offshore companies. So he said, why would I allow that company to operate and do something in my country? That doesn't make any sense. If they're not allowed to operate in their own country, they shouldn't be allowed here. If they want to register here or operate here, they should register like a local company and be subject to as much transparency. Those are some of the unilateral measures. I cannot keep speaking, but that's the idea.
Yeah. Does anyone else want to weigh in on that question, Maru or or Rachel, do you have thoughts? I think Rachel froze. Maru, do you have any thoughts on this? And then we are also like running out of time, so if you have some concluding remarks as well, please feel free to.
Sí, no, efectivamente coincido con lo que dice Andrés. Es clave y creo que también hay que... hablamos mucho de la recomendación, de la sugerencia, del hacer, y creo que tiene que haber medidas más directas de cumplimiento respecto de con quiénes vamos a establecer finalmente relaciones comerciales o no, a quienes vamos a permitir participar en nuestro país o no. Hay casos recientes, por ejemplo, de empresas que han querido venir a instalarse a la República Argentina para explotar un recurso mineral muy valioso, a través de una multiestructura societaria, y en el registro le pidieron que aclarara cuáles eran esos motivos, y ellos en realidad dijeron cuál era la mejor forma para venir a operar en la Argentina, y se les dijo que esta cadena debía ser directa, si no había ninguna necesidad ni ninguna explicación para poder justificar esta multiestructura, y al día siguiente habían traído su nueva sociedad constituida en los términos y conforme las exigencias que el registro público les estaba diciendo para venir a operar en nuestro país, con lo cual también es posible hacer esto. Tenemos que desmitificar algunas cuestiones en términos de beneficios que en realidad no son tales, sino que son más bien para dar opacidad a los beneficiarios finales. Con lo cual hay que seguir siendo bien estricto en esto y entender que aquel que no tiene nada que ocultar no va a tener tampoco ningún problema en venir a informar a sus beneficiarios finales y en hacer estructuras o personas jurídicas directas al momento de venir a realizar su actividad en el país que sea. En este caso era de Argentina, ¿no es cierto? Así que creo que sí es un tema clave.
Muchas gracias, Maru. I think we lost Rachel, so Cairo, if you want to give your views on this or also give some concluding remarks, because we are running out of time, please feel free to do so.
Yeah, I think as with everything else, it also boils down to the individual efforts of any country, to ensure that the laws that they are developing, the systems that they are developing, help that country to build wealth, to challenge and overcome poverty, to provide access to resources for its people, and ensuring that those that do business in a particular country are able to comply with the existing laws and international best standards. Having said that, I want to invite people to also look at the report, because part of what we have also done is actually provide an analysis of how beneficial ownership is playing out in practice in several countries. So for example, for the Africa report, you will see that we have serialized, we have provided some case studies in 4 countries. I think Senegal, Liberia, Kenya, some of the countries, and Cameroon are some of the countries that we have case studies on, looking at how beneficial ownership is playing out in real within those countries. So we invite people to look at the report. In addition to that, let me also mention that at present, if you look at the state, I think there's some progress, because having 23 out of 54 countries within Africa is some progress. However, there's a lot of space to push, number one, for countries to move from commitments to action, but also for the countries that have the laws to ensure that there is implementation, and not just implementation, but proper implementation that adheres to best standards or standards on bio, things like verification, identification, effective registration of who a beneficial owner is. So I think in concluding, to say that the report is accessible and we remain available to continue engaging more on the report, and to thank the participants as well as my fellow panelists.
Yeah, thank you so much, Cairo. We are gonna run we run out of time. So I wanted to thanks everyone that composed the panel, and especially Maru and Cairo as representing our partners as well in the production of the reports, because it was, I do invite everyone to read them. Thanks the interpreters as well, and everyone that joined the webinar today. It was very good. And yes, we hope to see you in the future. Thank you so much.
Yeah, and Florencia, before you go, to mention that the questions on the chat, we have tried to answer as many as we could, but still remain available to continue engaging.
Yes, exactly. Thank you so much.